Hi, my name's Lily, and today I will be delivering an educational video on behalf of the New South Wales Minister for Health on medical negligence for the Royal Australian College of Surgeons. Within the current frameworks of health law, tort law, and contract law, surgeons are subject to a continuous and concurrent duty of care owed to their patients. The significance of medical negligence in practice lies in its potentially severe impact on patient safety, the erosion of public trust in healthcare systems, and the legal consequences that may ensue. A health professional may be held liable for medical negligence if the plaintiff can satisfy the court that three key elements are present. Gett and Tabbitt highlights the requirement of a relevant causal connection between the breach and the harm as a means of determining whether the duty has been breached. First, it must be determined that a duty of care was owed to the patient. As established in Donoghue and Stevenson, a duty of care is constituted where a person is closely and directly affected by an act performed by another individual. As evidenced in the professional practice, surgeons maintain a direct relationship with patients through comprehensive diagnosis, clinical advice, and the formulation of treatment plans. However, this duty is not limited to direct relationships and does not require treatment to have commenced to be imposed. Albrighton demonstrates the postponement of treatment and seeking a second opinion does not absolve the medical practitioner's duty of care. It is reasonably foreseeable that patients may suffer harm under their care and accordingly requires surgeons to act with reasonable care and skill. Second, it must be established that the duty to exercise the requisite standard of care was breached. The standard derived from Section 5B of the CLA provides that the applicable standard is determined by considering if a reasonable person in the person's position would have taken those precautions. Fundamental standards in healthcare practice include the exercise of reasonable judgment, professional competence, and the duty to effectively communicate, particularly through the disclosure of relevant risks to patients. This falls under Section 5P of the CLA, whereby medical practitioners are required to disclose material risks to patients prior to the making of a decision and undertaking action. This was reinforced in Rogers and Whittaker, stating that if a reasonable person in the patient's position or a medical practitioner were likely to attach significance to it, disclosure must occur. Rendering the Bolam test obsolete, the Rogers principle promotes that all risks are acknowledged and informed to patients. However, Section 5.0 of the CLA, liability may be negated if a practitioner's conduct is generally accepted by professional peers in Australia, placing reliance on the practitioner's professional judgment and the subsequent course of treatment. Third, to establish causation, the patient must demonstrate on the balance of probabilities that the medical practitioner's negligence was a contributing cause, not necessarily the sole cause, of the harm sustained. This necessitates a connection between the breach and the resulting harm, engaging Section 5E of the CLA, which allocates the burden of proof to the plaintiff. These requirements include demonstrating that the risk of harm was reasonably foreseeable, the risk was not insignificant, and that a reasonable person in the circumstances would have taken appropriate precautions. Causation includes the but-for test, requiring a comparison between the actual outcome and a hypothetical scenario. Barnett's but-for test is used to determine factual causation, concluding that if the outcome would have been the same, causation cannot be substantiated. The common sense test under Section 5D of the CLA is reserved for exceptional cases and is typically inapplicable where negligence cannot be established as a necessary precondition to the harm suffered. This section is invoked to determine whether or not and why responsibility for harm should be imposed on the negligent party. Moreover, the common law doctrine of remoteness of harm limits the scope of a defendant's liability by determining which consequences of a negligent act are sufficiently connected to warrant legal responsibility. Overall, medical negligence claims are assessed through a combined statutory and common law framework, seeking to balance patient rights with protection afforded to healthcare practitioners from unwarranted liability. Despite this, medical negligence persists in forms such as misdiagnosis, surgical errors, medication mistakes, and the failure to obtain informed consent. Medical negligence has consequences on patients, surgeons, and institutions. For patients, as negligence has morphed from primarily covering physical injury and property damage to an action over economic loss and psychiatric diseases, it is evident that a patient's harm may be both immediate and long-term. Consequently, the harm resulting from negligence may encompass physical, pathological, psychiatric injuries as well as death. Such outcomes have profound effects on patients. In addition to the injury, patients may endure prolonged pain, delayed recovery and rehabilitation, and the exacerbation of pre-existing conditions or disabilities. Psychological consequences, including anxiety and depression as common trauma responses, may erode patient trust in healthcare providers. Moreover, the financial implications of negligence can be substantial, with patients facing significant medical expenses, ongoing care costs, and the loss of income. As negligence attracts compensatory damages for economic or non-economic losses, and sometimes special damages, patients may also incur considerable legal fees in seeking compensation. Surgeons found liable for medical negligence may face significant repercussions beyond civil litigation, including reputational harm, psychological distress, including the second victim mentality, and damage to future career prospects. While professional indemnity insurance generally covers financial liability, the litigation process can be emotionally taxing and time-consuming. A finding of negligence may also trigger disciplinary action by the Medical Board of Australia, potentially resulting in reprimands, practice restrictions, suspension, or deregistration. These outcomes can severely impact a surgeon's ability to practice, with potential employment terminated and limited opportunities within high-profile institutions. Medical negligence can also have significant implications for healthcare institutions, which may be held vicariously liable for the negligent acts of their employees. Where a patient suffers harm as a result of an employee's conduct, the institution itself may be subject to legal action and required to pay damages. Such cases often attract public and media attention, potentially damaging the institution's reputation and eroding public trust. Beyond reputational and operational consequences, institutions may also incur further financial burdens, including the cost of implementing mandatory staff training, policy reviews, and enhanced risk management protocols. The prevention of medical negligence in surgical practice requires a multifaceted approach, encompassing clinical competence, effective communication, system-based awareness, and strict adherence to legal and ethical obligations. In the Australian context, these preventative strategies are further shaped by national safety standards, professional guidelines, and medico-legal responsibilities. Maintaining clinical competence through ongoing professional development is essential to ensuring safe and effective care. Adherence to established clinical protocols minimizes variability in practice and promotes decision-making aligned with current best practice standards. Obtaining valid and informed consent is a critical legal and ethical requirement, ensuring that patients are fully aware of the risks and benefits associated with proposed procedures. Clear and transparent communication is also vital, as miscommunication can contribute to clinical errors and undermine patient trust. Comprehensive documentation, including clinical decisions, surgical procedures, patient interactions, and follow-up care, not only supports the continuity of care, but also serves as a protective legal record. Furthermore, the implementation of safety checklists and structured risk management protocols contributes to a standardized and systematic approach to patient care, thereby reducing the likelihood of adverse outcomes. So remember that medical negligence is a critical concern in surgical practice, carrying profound consequences. As surgeons, it is your duty to uphold the highest standard of care for your patients. Preventing negligence involves more than skills, it demands effective communication, informed consent, and adherence to protocols.